Hey everybody, Derek Christensen here. I'm the owner of Legion Law, a premier estate planning and probate firm in Dallas, Texas. Today I wanted to talk about marital agreements that will change the property type that you own. However, before I dive into that, I wanted to let you know how to reach out to me. You can find me at my email, Derek, D-E-R-E-K, at legionlawplc.com, or you can go to my website at www.legionlawplc.com. So with that, let's dive right in. Now, I made a video earlier about community versus separate property and the consequences of those types of property in estate planning. And just to kind of give a really brief summary, essentially, if you have separate property, that is all property acquired before your marriage and whenever you receive it from an inheritance or a gift from another person, or when you agree to it, which is what we're talking about in this video. That's all separate property. And community property is all property acquired at any time during the marriage that's not proven to be separate property. So most of the time, anything during the marriage is community property, even if you earn money from different sources, one person spends more than the other, it's titled a certain way, doesn't matter. It's almost always community property. So if you ever wanted to change that, and to be clear, in the estate planning world, this is a big deal because you are allowed to take care of all of your separate property and half of your community property. But the other half of your community property goes to your spouse and they can take care of what separate property they have. So if I have a will that says I give everything I have to my brother instead of to my wife will say, well, that's all your separate property and half of the community property, but that other half of the community property goes to me instead of your brother. So that's the big deal about it. And if you want to change that, then you need to very clearly have an agreement. Now, most of the time, these come in the form of premarital agreements or prenups, as they're known. And obviously, people know what prenups are. They are the documents that define what happens in the case of a divorce. And more specifically, they state, this is what's going to happen. This is how we classify property and who gets what. But there's the same exact thing for death as well, or for while you're still alive. You can classify anything as any type of property as long as you both agree to it. Now, these agreements need to be what's called arm's length, which means that you both have attorneys. So both of you have to lawyer up, technically speaking. You have to get together and you have to talk about who gets what, how are you going to split things up. And the main questions are always asked, who gets the corpus and who gets the income of the asset. Now, the corpus is going to be the initial lump sum, however much it's worth on the fair market. And then the income is obviously if any kind of cash comes from owning that asset. So, for instance, if I put $1,000 in AT&T and then it goes up to $5,000, the corpus is $5,000. So we have to figure out who owns that $5,000, who owns that appreciation of $4,000, and who needs to pay taxes on that. But also, we need to figure out how do we classify the property or the income that comes from the dividends of AT&T. So if I'm getting cash every single quarter from AT&T, I need to be able to clarify this is my separate property or it's our community property, the cash incoming, and separately I need to figure out what are we doing about this corpus, the original amount. So that's really important. You need to be able to flush out, again, those two things when it comes to each asset that you own, plus what happens whenever you pass away or get divorced. Is it community? Is it separate property? And so you need to really flush that out. And these agreements are very specific. They need to, again, specify, they need to be arm's length, but also they need to specify with very strict specificity that of which asset you're talking about. So you need to say the account ending in 4321, whatever. And you need to be able to go to in front of a judge and say, we have so much specificity in this document, there's no way that anybody could misinterpret what we were trying to accomplish. And if you fail to mention any kind of asset in there, then the asset is going to be whatever it is by default. So if I forget to mention my house or my car or whatever, that is going to be what it is by default, and most likely it's community property. So either way, these are all tricks and pointers that you want to really flush out, because at the end of the day, if you do it wrong, or if you don't do it arm's length, or if you just kind of whatever, if you just wing it, then those designations may not be accurate, or they could get challenged later on. Oftentimes in divorces, they get challenged very frequently, and it's actually gotten to the point where people challenge the validity of these kind of agreements very frequently because they don't like them after they've signed them, even though at the time they signed them, they were good for it. And to have another attorney on your side is to help explain the consequences of what type of designation will accomplish what. So again, you should get your own attorney. I know that sounds more expensive. I know you need 2 attorneys in this circumstance. So what the heck? It's frustrating for sure. But if you spend $3,000 right now to make sure it's done perfectly, then it's not going to cost you hundreds of thousands of dollars later on whenever everything falls apart. So that's kind of the thought process behind that. Again, there are specific languages that you need in there. You need to have what happens if people breach, what happens if, this asset is sold, the proceeds, who pays taxes, all sorts of different considerations you need to throw in there. And honest to goodness, considerations you're probably not thinking of as you think, oh, I love my wife. I just want to sign this one random document. So either way, be more than happy to help out if you have any questions or concerns on that. My name is Derek, like I said, and you can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can go to my website where you can go to our Contact Us page and schedule a free consultation over the phone directly onto my calendar. So thank you so much for watching and have a great day.